Hi, I'm Russ Weninger. I'm a wills and estate planning lawyer in Calgary, Alberta, Canada. Today I'm going to go over the basics of enduring powers of attorney. A will protects your loved ones. However, an enduring power of attorney protects both you and your loved ones. Everyone wants to know that their spouse or parent who is suffering from some sort of mental incapacity issue, that they're being properly taken care of. They want to know that their loved one isn't being taken advantage of, and they want the peace of mind of knowing that the person's finances are in order. So now the million-dollar question is, well, what happens if you don't have an enduring power of attorney? Well, if you become mentally incompetent and you don't have an enduring power of attorney, then it's easier for others who may want to take advantage of you financially to be able to do so. On the other hand, it's more difficult for those who actually care about you to be able to provide you with assistance, since most businesses and organizations that you may be dealing with in some sort of financial way, they'll require proof that a family member a friend who is assisting you is actually legally authorized to represent you. So if you become mentally incompetent and you don't have an EPA, an enduring power of attorney, then a family member or a friend may have to begin a very complicated and costly legal process where they go to court to be appointed as your legal representative. When you're doing an enduring power of attorney, when you're drafting one of these, you'll list one or more financial representatives and may also specify certain conditions that have to be followed by your representatives. Often an enduring power of attorney will list a primary representative and an alternate representative. Joint representation is also possible. For example, if you want to appoint two children to both represent you at the same time. An EPA should also indicate how it will be determined whether you are mentally incompetent. For example, it's common to specify that at least two medical doctors will be required to determine whether you are mentally incompetent. Now, in terms of who you should pick as a representative, oftentimes a spouse or common law partner is a good first choice for the representative or attorney role. And in this context, attorney doesn't really mean lawyer, it just means a representative. An adult child can also be a good choice, perhaps as an alternate attorney, in case your spouse or partner is unable to act. If you're single or estranged from your spouse or partner and have no adult children, then oftentimes a sibling or adult niece or nephew may be a good choice. Sometimes people will pick parents for this role, but keep in mind that your parents will likely die before you. It's not usually a good idea to pick parents as attorneys unless you're still quite young and your parents are still relatively young and healthy. Please check out my upcoming video. In that video, I'm going to go over the basics of personal directives. Hopefully you found this video to be helpful or informative in some way. And if you did, please feel free to like it or share it or to even subscribe to my channel. If you have a question, please feel free to leave it in the comments section and I'll do my best to respond. While I don't want to give specific legal advice in the comments section, I'll try my best to answer general questions as long as it's understood that my responses to comments should not be taken as legal advice and that social media interactions are not considered lawyer-client interactions and that your safest course of action is to consult directly with me or another lawyer if you have a legal issue or would like to prepare a will. Thank you.